Right stand. I'm Griha Atul. The Supreme Court of India has refused bail to activists Umar, Khalid and Sharjeel Imam in the 2020 Delhi riots larger conspiracy case, even as 5 other co-accused were granted conditional release. The bench found that the prosecution's material discloses a prima facie case under the Unlawful Activities Prevention Act against Khalid and Imam and held that delays in the trial cannot be treated as a trump card in UAPA bail matters. At the center of today's ruling is Section 43D5 of the UAPA, a statutory bail bar that requires courts to refuse bail if there are reasonable grounds to believe the allegations are prima facie true. A test critics say comes perilously close to assessing guilt before trial. Now, this brings us to a fundamental question now animating legal and public discourse. Where should the line be drawn between legitimate dissent and criminal conspiracy? Is the state's expansive invocation of anti-terror law in a politically charged context a necessary tool for public order, or does it risk criminalizing dissent and eroding the presumption of liberty, especially where the accused have spent more than 5 years in custody without a trial? As this case moves forward, it is these competing imperatives, statutory safeguards, individual liberty, and the boundary between protest and peril that will shape the contours of both law and public debate in India tonight. So let's break it down point by point as to what transpired in the top court today. The petitioners argued that Sharjeel Imam and Umar Khalid have faced prolonged incarceration without trial. But the Supreme Court observed that both played a central role in the Delhi riots conspiracy, making their detention justified. Next, while the defense claimed that Umar Khalid was not even in Delhi when the riots erupted, the court said that there is prima facie evidence against both the accused. The petitioner also pointed out that Khalid has spent over 5 years as an under trial. The court made a granular distinction between the accused then, finding that Khalid and Imam stood on a qualitatively different footing from the others, warranting continued custody under the statutory bar. The petitioner further argued that they were simply exercising their right to protest, but the court stressed that they were actively planning and organizing the protests, which escalated into violence. Finally, on the claim that the UAPA does not apply, the court emphasized that national security and preservation of public order are crucial and strict provisions are necessary in such cases. Now, the Delhi police has presented certain clips also. We will go to that. But before that, let's take a look at the reactions that are also coming in.
नहीं, कोई कमेंट नहीं है, नो कमेंट। किस तरह से देखते हैं? नो कमेंट, अनफॉर्चुनेट। नहीं, कुछ नहीं कहना है, जो जजमेंट आ गया वो आपके सामने है, उसमें क्या कहने की जरूरत है?
Let's now take a look at these clips that have been presented by the Delhi police, which the Supreme Court says amount to prima facie evidence enough to deny bail at this particular stage. So first, the court took note of Sharjeel Imam's alleged call to Muslims to, quote, cut off the chicken's neck, a phrase the prosecution says was a call to action. Second, there is an alleged mobilization to paralyze the government through mass road blockades aimed at disrupting normal life and also the state functioning. Third, the prosecution pointed to statements suggesting that action at protest site would humiliate the government. Also, fourth, there is reference to a threatening remark about teaching the court a lesson, which the cops argue reflect a confrontational stance towards constitutional institutions.
5 लोगों को बेल देने का वो बिल्कुल ही दुर्भाग्यपूर्ण है और मेरे लिए ही नहीं बल्कि हम बहुत सारे लोग पीड़ित हैं, पीड़ितों को फांसी देने का काम किया है और इस तरह से बिल्कुल भी ठीक नहीं है। हम तो यही कहना चाहेंगे, इनको बेल देना बिल्कुल ठीक नहीं था और आगे ये बताया जा रहा है कि इनका डे टू डे ट्रायल चलेगा। डे टू डे ट्रायल में मैं अनुरोध करना चाहूँगा कि 6 महीने के अंदर ट्रायल करके इनको कम से कम फांसी की सज़ा दी जाए।
So the continued jail for Khalid and Imam has sparked a fresh political row now. The opposition has alleged that the Bharatiya Janata Party is playing vendetta politics, but the BJP counters that the Supreme Court ruling reaffirms judicial independence. The opposition now claims that the centre is tightening screws, particularly against Muslims, for political gains, while the BJP says that the verdict is a warning to court urban Naxals and also Islamist sympathisers. Finally, the opposition questions the centre's role, calling it deeply suspicious, but the BJP insists that the foreign pressure cannot sway Indian courts. Now, with this political discourse continuing on the sidelines, as the Supreme Court weighs UAPA bail standards against 5 years of pre-trial detention, the pivotal question facing the nation is this: at what point does robust democratic dissent end and criminal conspiracy begin?
अनफॉर्चुनेट है, जमानत मिलनी चाहिए। ट्रायल में अगर ये दोषी पकड़े जाते हैं तब तो आप इनको जेल में रखो, लेकिन इतना दिन जेल में रखना बिना ट्रायल, ये अनफॉर्चुनेट है। और सरकार जिस तरह की है इसमें राजनीति कर रही है कि देखो मुसलमानों क्या हम चूड़ी टाइट कर रहे हैं।
जिस प्रकार से उन्होंने ये कृत्य किए, ये दिखाता है कि जो दिल्ली में दंगे किए गए वो दरअसल संयोग नहीं, सोचा समझा प्रयोग भी नहीं, मैं तो कहूँगा हिंदू विरोध का और यही एम फैक्टर, वोट बैंक फैक्टर का सबसे बड़ा उद्योग था। ये दंगे जो थे वो स्पॉन्टेनियस नहीं, स्पॉन्सर्ड थे।
Joining us tonight is Senior Advocate of the Supreme Court, Mr. Mahesh Jethmalani. Mr. Jethmalani, the first question I'd like to ask of you. The court's application of UAPA's prima facie evidence standard under the Section 43D5. Do you believe it strikes the right balance between national security and also the individual's rights?
Well, I mean, yes, certainly as far as Sharjeel and Umar Khalid are concerned, it does. I mean, I think that's. I don't know the evidence about the other 5 people who got bail, so I can't really, comment on that. I have not read the detailed judgment yet, so I am speaking from a bit of limited knowledge, mainly provided by the press. So I have to say that yes, I mean, at least as far as these two are concerned, it's a very good balance because the offence is extremely serious. The consequences of what was being planned was very anti-national and would have drastic consequences to the nation. And if there's a strong, and UAPA in any case has strict provisions for bail. So both in law and in facts, I think the judgment is well grounded.
Mr. Jethmalani, the court made a granular distinction between the accused, finding that both Khalid and Imam stood on a qualitatively different footing from the others, warranting this continued custody under the statutory bar. What do you make of this, sir?
Well, look, in a sense, they're all anti-nationals. Anybody who had any part of this conspiracy to destabilize, the nation, because this was really a regime change operation, which was inspired and probably masterminded by overseas enemies. So anybody who had a role in this, right, according to me, is complicit and should not have been given bail by and large. But if you had to make a distinction between, it happened even in the the bomb blast of 1993. In that case, you had concentric circles, and you first gave bail to the lowest in the rung of complicity, and then you didn't give bail to the main masterminds of the conspiracy. That's how it was done in the 1993 blast case. So yes, this does happen, that you let the lesser people, the people who execute the job without being the masterminds, as on bail, while you keep the masterminds and the chief urgent provocators in custody.
Vocal critics of UAPA are having their say yet again. Many are calling this very unforgiving law, and this also goes on to become a symbol of justice system being under strain. What do you make of advocates who are speaking in this particular direction, sir?
I think they're shedding crocodile tears. I think they're lamenting only for their clients, right? This is the very sovereignty and integrity of India. These cases are those which strike at the very territorial integrity of India. The attempt is, and when you're acting, I mean, if the charges are true, and I'm still leaving that open, right? Because they have to undergo a trial, so I don't want to say too much. But if they're true, these people are nothing short of fifth columnists, stroke traitors. I mean, they're anti-nationals. Well, what can be a more serious offense? Does the nation's integrity not matter to you? I mean, what do you mean by giving a 7-minute video, right? On different days between December 1919 and January 2020, right? When you say things like the Siliguri corridor, they call the chicken's neck, right? The Siliguri corridor, basically, that 22-meter strip which connects mainland India to the northeast, it belongs to the Muslims, and we can cut it off at any stage, and we should. This is the language which today Mohammed Yunus in Bangladesh is talking like. He uses that language.
I mean, you in the past also have called this speech by Sharjeel Imam white-collar jihad, but do you think it is too soon to speak about the merits of the case, since we are only discussing on the fact that they have not been granted bail by the Supreme Court?
I am saying if the allegations are true, at the stage of bail, you release bail depending on the factual evidence, right? When people accused of serious offences move bail, they take that risk that the court is going to take a prima facie view. This is not conclusive. The grounds denying or granting bail, right, at this stage, before the trial is actually started, right, are not final conclusions. But they are saying that if these turn out to be true, this man will probably get a conviction and he's not entitled to bail today because these are very, very serious offences, right? It's not that the law is, it is true that the law is that jail is the rule and bail is the rule and jail is the exception. That is the law. But there's a caveat to that law. Where the offences are extremely serious and sinister, that presumption doesn't apply.
Okay. At the cost of preempting it, would you still call this end of the road for both Sharjeel and Umar?
Look, end of the road is when the judgment comes. So we have to await the judgment and see what the final verdict is. But yes, it certainly seems to be the end of the road as far as bail is concerned. And if these people really believe in their innocence, they should be pressing for an early trial. I think the whole country, including the accused, right, needs to have a quick trial. This is a 2020 very serious offence, right? And it's about time we started taking trial procedures seriously and moving it. What sticks in my neck is that a government changed because of a 2G scam. Until today, the appeal is not disposed of. So we don't want this to. We don't want this to happen in cases where the territorial integrity, the very sovereignty of India, is being attacked.
All right, so there's still one more year before they can go ahead and file another prayer for bail. But the Supreme Court said something very interesting, and I want to quote before you, sir. Continued detention has not crossed the constitutional impermissibility to override statutory embargo against the accused. This is rather interesting, but what do you make of this observation?
Well, all it says is that it's too soon to. I translate this as being it's too soon to release them on bail.
All right, thank you.
And perhaps if there is inordinate delay, which there shouldn't be, and this the prosecution should take note of, in disposing the trial, right? It is in everybody's interest, the whole country's interest, to expeditiously dispose of this trial now. Right? So the Supreme Court has given a warning that if you now lag behind, if you delay the disposing of this trial, if the prosecution delays, the accused delays always their own fault. If the prosecution delays, then there may be an opportunity for renewing bail because of the prosecution's lackadaisical attitude.
All right. Thank you so much, Mr. Jethmalani, for joining us on the broadcast. Let me now open this up to my other guests who join us on the right stand. Harsh Daya is a lawyer and political analyst, is with us. Also with us is Shahid Ali, another lawyer who joins us today. Let me actually begin with, in fact, Harsh Daya. I want to understand from you, what do you make of the observations, particularly with the court stressing that in such cases, we're talking about the delay in trial, that cannot be used as a trump card. And this was a significant observation that has come out of the court today.
Grihaji, when we talk about the today's court judgment and also the media trial that is being done, the media pressure that is being built by the left lobby, the Congress lobby, and the Islamist lobby in the country to grant these people bail, and them repeatedly calling Sharjeel, Imam, and Umar Khalid as intellectuals, I would like to point out one plain and simple fact that the jihadi intellectual provides the shoulder on which the jihadi extremist places his guns and targets Hindus. This has happened in Bangladesh, this has happened in Pakistan, this has happened in Kashmir, and this is happening all across India at the moment. These people are not only conspirators, but they are also rioters and terrorists. Let's not forget that. And why am I saying this? Because Sharjeel Imam, it cannot be denied. There is a clear video where he calls for the chicken neck of the country to be cut, and the passage between the other parts of India and Northeast to be cut down. He is clearly asking the Muslims in that particular video that the Muslims should come out, and that chicken neck belongs to Muslims. And if they gather in number of 5 lakh, then they will be able to sever the chicken neck from the rest of the country. Now coming to the court's, judgment, which says that the delay in trial does not translate into automatic bail. It is plain and simple that the delay in trial is a strategy of the defense, because the defense knows there is concrete evidence against these culprits who were involved in Delhi riots, who have blood of 53 people on their hands, who have blood of the innocent Intelligence Bureau officer, Mr. Sharma, on their hands. Then they know that they will be convicted for sure. That's why the delay in trial is being done as a strategy by the defense and not by the prosecution.
Okay. Mr. Shahid Ali, this entire argument that this is a prolonged incarceration, more than 5 years, under trial detention, none of that cut any ice with the top court of the country today. Sir, can you hear me? Mr. Shahid Ali? I don't think that audio link is through with Mr. Ali. We'll try and reestablish that connection. But Harsh Taya, what do you make of this particular argument, particularly coming on way of in fact, the advocates of both Sharjeel and Umar Khalid for that matter, the prolonged incarceration bit, particularly for Umar Khalid, all of this presented by Kapil Sibal did not really cutting any ice with the Supreme Court?
No, because the prima facie evidence is very strong and very clear. There are clear videos. There is a clear strategy that was laid in front of the court. If you read the police charge sheet, the portions of which are available in the public domain, and the portions of which have been quoted by the High Court in their judgment and by other courts in their previous judgments, I've gone through them. The clear 4 stages have been mentioned which these people followed. In the first phase of the events leading up to the riots, in the first phase, Sharjeel Imam, Umar Khalid, and all the co-conspirators, some 21 of them, they started with creating WhatsApp groups of different Islamic groups and different Islamic student groups. They were trying to consolidate all these people on these WhatsApp groups. And on those WhatsApp groups, there are clear messages where they call, where they say that the stockpiling of arms, ammunition, petrol bombs, and other stones and sticks should be done. There are clear messages. There are screenshots of those which have been included in the police charge sheet. Is that not enough? In the second phase, the physical mobilization of these Islamist groups and Islamist students was done in East Delhi and other parts of the capital, which is Delhi, and other parts of the country where these riots were taking place. A complete physical consolidation was being done. Physical mobilization was being done. In the phase 3 of their plan, in the phase 3, the stockpiling of arms, ammunition, petrol bombs, sticks and stones started. And in the fourth phase, the Chakka Jam started. And the Chakka Jam led to the riots in Delhi, which claimed lives of 53 people. All this evidence is on record. All this has been cited in the court orders. I've seen those court orders and I've gone through those court orders. And prima facie, a very strong case is made against them. The media pressure at this moment and the media trial should not be whether they should be granted bail or not. The media pressure and the media trial and the public pressure should be when will these people be hanged. They should be convicted as soon as possible. You cannot kill one IB officer an innocent IB officer who had nothing to do with these protests, nothing to do with these riots. He was dragged out of his house and he was killed in the house of an Aam Aadmi Party councillor, Tahir Hussain. Do you know how brutally he was killed? How brutally other Hindus were killed in these Muslim riots of Delhi? These were clearly orchestrated, these were pre-planned, and these people are the culprits.
Okay.
The trial or the media trial should not be whether
we
are getting
have
bail
Shahid
or
Ali
not.
back. We have Shahid Ali back. Shahid, I was earlier wanting to ask of you this key argument that of prolonged incarceration did not really work as far as the Supreme Court is concerned. So no bail for Umar, particularly because it is he who remains in jail for more than 5 years without a trial. But under UAPA, that did not cut any ice.
Absolutely right. Now, Honorable Supreme Court has decided. See, whether we like the judgment or not, we have to obey the Honorable Supreme Court's orders. We have to obey the Honorable Supreme Court's judgments. So, whatever Honorable Supreme Court has decided, we accept that with humility. So, there is no issue to that. Now, the question is that a person whose trial has still not been started, he is in custody. His custody is now continue to go on. So this really, according to me, now since the Honorable Supreme Court has decided, we should not say any words. But the other aspect of the case is that at least trial ought to have been started. Now,
But the court did make a mention of speedy trial.
Yes, see, there is a difference between the material available with the government or with the prosecution and the evidence which will be brought before the court, and thereafter after the procedure, which is the procedure for putting forth the evidences before the court or how the evidences have to be marshaled. Only thereafter the guilt will be proved. So tomorrow if he is acquitted, then the question remains that who will restore his life back.
Okay.
What the major part or the prime of his life he is spending in jail. So this really is unfortunate that Honorable Supreme Court ought to have directed the trial should be concluded in 1 year or 6 months. That direction has not come. So bail undoubtedly is a discretion of the Honorable Courts whether to grant or not to grant. But until unless the guilt is proved, my contention is that at least the direction ought to have been given by the Honorable Supreme Court. The trial should be completed within a time frame, because this is the clear violation of the fundamental rights or right to life.
One more argument against Sharjeel Imam, particularly Umar Khalid, because of the kind of international lobbying, and that's the accusation against Khalid particularly, because there are very many voices coming in from the US. I'm not just talking about the US lawmakers' letter, I'm also talking about the newly sworn in mayor of New York City, also writing that little note for Umar Khalid. All of this didn't seem to be working. That pressure on the Indian judiciary from outside quarters that many thought would really work hasn't really worked in favor of Umar Khalid.
See, our judicial system is competent enough. In fact, there is no requirement of any suggestions or intrusions by others. I don't believe in that. My contention is that if we would have given fair trial, time-bound trial, then undoubtedly the so-called world leaders, those who have been speaking now, could not have spoken. So in fact, we have invited them by virtue of not giving the time-frame trial. In fact, India is a country who gave appropriate defense even to Qassab. So we are known for that. Our judiciary is known for that worldwide, and that was appreciated worldwide. That we even provided advocate to Qassab. Now, in case of Umar Khalid, the trial has not been started. So that, in fact, is tarnishing the image of India.
Okay.
So I am very much concerned about my
Mr.
India.
Daya, would you like to come in here? This pre-trial detention that has been a subject of debate, not worked in favor for Umar Khalid, but is also causing a huge amount of chatter, and the debate continues, it rages on.
Grihaji, people on both sides are demanding just one thing, that there should be a speedy trial. Even I am demanding the same. Definitely the trial should finish within a limited time, but to say that it should finish in 6 months or 1 year, that is not justifiable. And my dear friend Mr. Shahid Ali would also agree to it, because justice delayed is definitely justice denied, but justice hurried is also justice buried. So both ways it is wrong. We cannot have a longer delay in trial, but there cannot be a time limit put on the trial that it should be finished, it should be completed and concluded in 6 months or 1 year, because that would be travesty of justice altogether. There could be some important evidences could be missed out, some things could be skipped in that. So there should be a speedy trial for sure. They should be brought to justice. If they are wrong, then they should be convicted. If they are innocent, they should be let him go
Okay,
off.
Mr. Ali, but there is one argument that is also coming in the way of why this trial was not done as it should. The pace is being questioned, is because there were delays on part of the counsel of Umar and Sharjeel, and not really the prosecution.
In fact, there are two sides always before the courts. The defense side, there is a prosecution side. Defense side may file application for bail. So filing application for bail can never be an obstacle in proceeding the trial. That cannot be construed as an obstacle basically. So if an accused is filing bail applications, after bail applications, if this is taken on its face value as this is true, then also who stopped the prosecution from proceeding the trial? Who stopped the prosecution from praying to the London trial court to proceed with the trial? Why the charges were not framed? Who stopped? Nobody had stopped. This was the responsibility of the government. This was the responsibility of the prosecution to proceed with the trial. So this absolutely is what should I say? This argument holds no water, saying that since the accused has filed bail application, therefore the trial could not be proceeded.
Okay.
In fact, we are advocates. We daily file bail application for accused, and sometimes many bail applications used to be filed. We have seen many cases wherein lots of bail applications are filed, but trial always goes on. Trial is not stopped on account of that the bail application is pending. A trial should not be stopped basically. Now, see, there is one other aspect. He has already undergone 5 years. Trial has not been started. Now, one of the arguments that the hurried trial will also devastate the outcome of this case. See, we have seen Lal Killa shootout case. We have conducted Lal Killa shootout case when the trial was conducted on day-to-day basis. What's the problem in that? Let one particular court is assigned to this task, and let the trial is conducted on day-to-day basis.
Okay, Mr. Daya, why was this case allowed to be dragged for so long?
Or more than, or even lesser than 1 year.
Mr. Daya.
So that should not
Coming to the point of bail and delay in the trial, let me make it clear. When the bail applications were filed, first of all, they straight away went to the higher courts, where the higher courts told them that they should first file a bail application in the lower court itself, where the trial is happening.
Okay.
They didn't do that, and deliberately, at different stages of the bail application and at different avenues of bail application, be it High Court, be it Supreme Court, several times deliberately the defense took adjournments again and again. More than 20 times adjournment was taken by the senior lawyers of Umar, Khalid and Sharjeel Imam, more than 20 times at the Delhi High Court itself. When you are taking adjournments in the bail application so many times, then that shows your seriousness, because you know the prima facie evidence is so strong and the charges are so strong. Under the stringent laws of UAPA, getting bail would be next to impossible. So all this theatrics was done to create a media.
So there is another argument that stays around UAPA, that is the stringent sections of UAPA being weaponized to curb political dissent, and this will come into the discourse yet again now that this bail has been denied by the topmost court of the country.
No, then let's do away with UAPA and all the stringent laws of the country which are keeping the country safe, because then we'll be letting these terrorists walk away and they would get bail easily, and they would be going out, they would be meddling with the witnesses, they would be meddling with the evidences, and then a proper trial can never take place, because they are such dangerous people. The lobby behind them is very dangerous. They are terrorists, and if they are allowed to walk free freely on the streets of Delhi, then nobody is safe, and even the evidence and the witnesses wouldn't feel safe. The witnesses wouldn't feel safe, and the evidence would be meddled with, and a proper trial will not take place if they are given bail.
Right. Thank you so much, Mr. Daya and Mr. Ali, for joining us on the broadcast and discussing this important verdict that's come out of the Supreme Court denying bail to Umar Khalid and Sharjeel Imam while granting it on a conditional basis to the 5 other accused in the larger conspiracy case in the 2020 Delhi riots case. We are now getting some breaking news on the broadcast. Let's take a look at that. And this is as per TVK sources. They are revealing to CNN News 18 that the party is open to any alliance provided the front is spearheaded by TVK and makes Vijay the chief ministerial face for Tamil Nadu. Remember, this comes after speculations of talks between the TVK and the BJP. My colleague Poonima Murli is now with us on the broadcast. Poonima, which way is TVK deciding to swing? Earlier, there were conversations around Congress speaking with Vijay. Now there is also the Bharatiya Janata Party. What is it looking like really for Vijay's party?
Well, sources from the TVK say that the party is open to an alliance with any party that accepts Vijay as a chief ministerial candidate and that accepts Vijay and the TVK to spearhead the front. Remember, this at time when Home Minister Amit Shah is in Tamil Nadu. When we asked them, initially TVK said that they will never form an alliance with the DMK, which is a political enemy, and the BJP, which is the ideological enemy. But now they say that anyone who is ready to accept Vijay as a CM candidate can join hands with the TVK. Now this leads to speculation of what happens next. TVK keeping options open at this point in time is what we are given to understand. TVK is also holding talks with the Congress, but at the moment DMK Congress both have denied any sort of rift within the India Bloc alliance. So now we'll have to wait and see how the discussions between TVK and BJP now will happen in the coming days.
Right, but isn't it putting the DVK on a very desperate footing, Poonima, considering they also making the suggestion that they are open to an alliance with any party provided TVK is spearheading that alliance and Vijay becomes the chief ministerial face? It could be either BJP or Congress.
Absolutely. It could be either the Congress or the BJP. But right now, TVK, from saying that they will never form an alliance with the BJP to now saying that any party that is open to Vijay being the CM face can join hands with the TVK. Of course, keeping its options open, not just with the Congress, but also with the BJP. But sources from the ADMK and the BJP say that Edapadi will be the CM candidate. At least at the moment, it looks like ADMK will be spearheading the NDA front, and in all probability, that will continue. So TVK joining hands with the NDA looks unlikely at this point in time, as the BJP and the AIADMK sources reiterate that Edapadi will be the CM face of the NDA.
Right. Thank you so much for that, Poonima. So, a big news break that we are bringing for our viewers from Tamil Nadu. TVK wanting to swing either way, particularly with the Bharatiya Janata Party. Let's see what does the AIADMK really have to say about that, because the condition that's coming in from Vijay's party is that Vijay needs to be the chief ministerial face for Tamil Nadu. Now, ladies and gentlemen, at the heart of India's fight against gender injustice lies Beti Bachao, Beti Padhao, a campaign meant to redefine our national conscience and protect the dignity of every woman. Yet today, a stark contradiction has thrust that very campaign into the spotlight. On January 4th, the Haryana government granted a 40-day parole to Gurmeet Ram Rahim Singh, serving a 20-year sentence, remember, for raping 2 of his followers and a life term for the murder of a journalist. This is his 15th release out of prison since his conviction in 2017. For critics, this is not just another parole granted under the law. This is a deeply unsettling signal, a message that resonates loudly across India's political and social landscape. Since 2020, Ram Rahim has spent over 400 days outside prison, often in extended furloughs that have repeatedly coincided with elections in the state of Haryana, Punjab, Rajasthan and beyond. Observers point to this timing not as coincidence but as calculated, aimed to leverage the vote bank influence of his vast Dera Sacha Sauda. What's more striking or troubling rather, is who is raising the alarm. Where are the political voices that champion Beti Bachao when a convicted rapist enjoys preferential freedom? The strongest objections are coming not from party leaders, but from the families of the victims, Sikh and civil society groups questioning whether justice has become negotiable when weighed against political expediency. Tonight we ask, what happened to Beti Bachao? And how does the state justify this pattern of parole that undermines the very ethos of gender justice? Now, why does Gurmeet Ram Rahim enjoy what critics call easy freedom? Let's break it down further. First reason that we'd like to put out for our viewers is that he commands a massive following. That is over 1.25 crore followers who sway more than 26 assembly seats in Haryana alone. Reason number two, he operates a formal political arm under his direct guidance, enabling organized electoral interventions. The third thing that we'd like to put out is that his influence cuts across party lines. He has backed multiple parties, including Shiromani Akali Dal in 2007, the Bharatiya Janata Party in 2014. Also, this was for the Lok Sabha and the Haryana Assembly elections, and also the Congress at times. Now, Ram Rahim enjoys a large Dalit and lower caste support base, marking and making him politically significant. And last but not the least, parties prefer quiet engagement over open confrontation to avoid being labelled anti-Dalit or anti-faith. So the bigger question is this truly a prison term, or has it turned into a political picnic for a convicted rapist, also a murder convict in this particular case?
वो रिकमेंडेशन के बाद अल्टीमेट फैसला तो कोर्ट कचहरी में होता है ना, तो अगर कोर्ट ये समझता है, अगर सरकार ये समझती है कि इनके बाहर आने से कोई नुकसान नहीं है, तो पैरोल मिलती है।
देखिए, कानून सबके लिए बराबर होना चाहिए। मैं समझता हूँ कि किसी भी व्यक्ति को कोई स्पेशल छूट नहीं मिलनी चाहिए, सबके लिए कानून बराबर है और उसी एक ही धारणा होनी चाहिए।
Let me, in fact, bring in a very special guest to start this debate. Anshul Chhatrapati is the son of the victim journalist Ramchandra Chhatrapati, is now with us on the broadcast. Anshul जी, बहुत शुक्रिया हमारे साथ जुड़ने के लिए। क्या कहेंगे, 15वीं बार जेल से बाहर आ रहे हैं, मर्डर कॉन्विक्ट हैं, डेरा सच्चा सौदा चीफ जो हैं गुरमीत राम रहीम सिंह।
मैं सबसे पहले तो ये कहना चाहूँगा कि जिस तरीके से एक बार बार सत्ताधारी जो पार्टी है वो पैरोल को, फरलो को हर बार जस्टिफाई करता है, और आज बिल्कुल एक ताज़ा बयान है सूबे के सीएम नायब सैनी जी का, तो उन्होंने कहा कि ये कोर्ट का मैटर है और कोर्ट पैरोल देता है। तो ये बिल्कुल मैं ये कहूँगा कि ये प्रदेश की, देश की जनता को गुमराह करने वाला बयान है, और सूबे के सीएम को इस तरीके का भ्रमित बयान जो है वो नहीं देना चाहिए, क्योंकि ये बिल्कुल प्रदेश सरकार का प्रेरोगेटिव होता है पैरोल किसको दिया जाना है, किसको नहीं दिया जाना है। और रही बात ये इस तरीके से जस्टिफाई करना कि ये हर एक कैदी का राइट है, तो मैं यहाँ ये कहूँगा कि गुरमीत राम रहीम जो है वो एक नॉर्मल कैदी नहीं है। आप कोई एक उदाहरण बताइए, कोई एक एग्जांपल बता दीजिए पूरी स्टेट के अंदर कि जिस व्यक्ति के खिलाफ वर्डिक्ट आना हो और आपको आर्मी डिप्लॉय करनी पड़ी हो प्रदेश के अंदर, और 38-40 जो है लोग पुलिस की गोली से मारे गए हों उसको कंट्रोल करने के लिए, लॉ एंड ऑर्डर को। तो ये सारी सिचुएशन जो है वो बताती है कि गुरमीत राम रहीम एक साधारण और एक आम कैदी नहीं है। और जब 2017 में वर्डिक्ट आया और वर्डिक्ट के वक्त जिस तरीके से पुलिस के आला अधिकारी बार बार ये बयान देते हुए दिखे कि दंगे फैलाने के पीछे गुरमीत राम रहीम का हाथ था, उसने इशारा किया, एक रेड बैग जो है वो लहराया और उसके बाद पूरे पंचकुला में दंगे फैल गए। तो कहीं भी एक एफआईआर तक लॉन्च नहीं हुई पूरे हरियाणा के अंदर जिसमें दंगों के लिए गुरमीत राम रहीम को उसके ऊपर जिम्मेदारी तय करने के लिए कि कौन जिम्मेदार था इन दंगों के लिए। और उसके बाद इतनी सारी जांच बैठाई गई पंजाब एंड हरियाणा हाई कोर्ट द्वारा, आज तक किसी भी जांच का कोई जो है वो नतीजा नहीं निकल पाया। तो कहीं ना कहीं आज भी राजनीतिक दल जो हैं और प्रदेश सरकार जो है वो मैं ये कहूँगा कि राम रहीम और उसके वोट बैंक और इस सब के तले दबी हुई है, और वो आज भी उसको प्रोटेक्ट कर रहे हैं। उसको खुली हवा में लाने के लिए आज भी उसकी पैरोल को जस्टिफाई किया जा रहा है। गुरमीत राम रहीम एक रेपिस्ट है, एक मर्डरर है, और इसके अलावा मैं ये कहूँ कि बहुत सारे मामले अभी
बिल्कुल सही कह रहे हैं अंशुल। कैसा लग रहा है ये सुनने में कि स्टेट मशीनरी भी दबी हुई है एक रेप कॉन्विक्ट, एक मर्डर कॉन्विक्ट के आगे। Let me open this up. We have more guests who are joining us. Naveen Chomol, who's an advocate, is with us. Also with us is Pratik Som, advocate and national spokesperson of the JJP. And Kishle Pandey, another advocate from the Supreme Court, is also joining us on the broadcast. Pratik, let me begin with you. Why is nobody speaking up against the repeated paroles for Gurmeet Ram Rahim? How is he getting this kind of a leeway? It's not a leeway. We're calling it a political picnic because the political parties are hand in glove. They are all doing it for vote bank politics.
Yes. So first of all, let me clarify this, that the parole decision is clearly an executive decision, and there has been judicial precedents which I think the government of Haryana is either ignorant or either they are bold enough to ignore the Supreme Court precedents. Let me tell you, in 2016, there was a judgment, landmark judgment, which is Union of India versus Sri Haran at alias Murugan. What did the Supreme Court say? Supreme Court say life imprisonment means imprisonment for the remainder of natural life, thereby implicating that executive discretion cannot dilute life sentences through backdoor mechanism. And then subsequent year in 2017, one more judgment came, Asfaq versus State of Rajasthan, where Supreme Court says that liberal parole policies for heinous offenders undermine the rule of law. Temporary release of convicts must balance reformation with societal interest. The reason I quoted both of these judgments is that the law of the land, the diktat which has come from the Honorable Supreme Court insofar as question on parole is concerned, is a law of a land. It is not a joke. Out of 3649 days of imprisonment, you are giving a parole for almost 400 days. That constitutes to 12% of liberty of the convict to be in the jail. This is some kind of mockery which government of Haryana is doing, and they are also ignorant about that he is not convicted under some small offence. He is convicted under heinous offence.
But why do the criteria do not really suggest? And let me read this out. The eligibility criteria to grant parole, and this is what it says: minimum portion of the sentence by the accused, by the prisoner, by the convict in this particular case must be served, which is only, and I must underline, at least 1 year for regular parole, excluding remission periods. So this is criteria number 1. The second criteria is demonstration of good behavior. The third is that a gap of 6 months before every second parole should be granted, should be kept in mind, and positive reports from district police and magistrate that confirm that he is not a risk to public order security. Why are the victims crying and why are they up in arms if he is not a risk?
Talking about remission. This case is of parole. There is a difference, categorical difference between a parole and remission.
Absolutely.
Parole is temporary.
Absolutely, but I want to understand why the provision is not stringent enough. Kishle Pandey is also with us. Kishle, what do you make of this? And what do you make of the loopholes that have been so rigorously misused by Gurmeet Ram Rahim in being given these 400 days since 2020 that he's out of jail on these very, very stringent charges that he's been convicted for? Rape and murder.
Well, let us stop hiding behind the technicalities. Parole was never meant to sponsor birthday celebration of power. It was meant for funerals, for hospital beds, for human emergencies. And I am in consonance with Mr. Som's citations which you have just read out. And I must mention that a man convicted of rape has now walked out for the 15th time. 15th times. And tonight the daughters of this country are watching. They are asking whether the promise of our court that we will punish the guilty to the hardest extent was a sole assurance or a hollow sentence. When a life convict repeatedly steps out, punishment stops being punishment and it starts looking like a schedule. It is absolute mockery of law. This is not a reform. This is not a compassion. This is a mockery of victims' agony, a delusion of deterrence, and a dangerous message to society that influence negotiates incarceration. And every rapist and every criminal, that if you have power, you have money, you have a contact, you have a resource, you can negotiate the punishment. And this is how the punishment operates. Then the common man is entitled to ask one brutal question: why to fear the law at all? And I beseech Honorable High Court, I pray Honorable High Court through your channel to take the suo motu cognizance of this conduct of the state. This is a high time to pass the strongest message to the citizens and to the rape convicts like Ram Rahim that this kind of conduct will not go unnoticed. Here, the parole has been granted to celebrate the birthday celebration of the successor. The parole has been designed for these kind of things.
He was out on parole on his own birthday.
No, to celebrate the birthday
he was.
of
This
the
is
successor.
right now. This is the
Yes,
15th one.
correct,
But in previously he was. Naveen Chomal, there was a lot of outrage when there was this Sengar case from Uttar Pradesh, a suspension of conviction of a convicted felon who was accused of rape and also custodial killing. There was a lot of outrage. The court had suspended that sentence and it had to backtrack because this person was a threat to the victim and the victim's family. How do you justify the parole that has been repeatedly granted to Gurmeet Ram Rahim? We have one of the family members of a victim who's been killed by Gurmeet Ram Rahim, a journalist in this case. Anshul is with us. आप कैसे गारंटी करते हैं कि उनके परिवार को कोई थ्रेट नहीं होगा? ये बार-बार बाहर आ रहे हैं.
Griha ji, I would like to have some space to speak.
Sure.
Because the views seem to be all coming all against Ram Rahim. So let me explain the facts in all details.
Sure.
The law points also. But at the very outset, my utmost respect for Anshul ji and full compassion for him. And definitely, I don't say that Ram Rahim is innocent or what you say, is absolutely clean person. So definitely, justice has to be done to the family of Anshul ji. There is no doubt about it.
On what grounds did he get out? To celebrate a birthday of his successor?
Now, coming to the issue of parole, let me speak very generally, then we'll see how Ram Rahim has been getting it. See, the concept of parole is very, based on humanitarian concepts. And it is not just confined to Ram Rahim.
How is birthday humanitarian?
Yes, I am understanding. See, birthday is just a matching with other things. He must be requiring the parole for other works also which his ashram is handling. So definitely there are multiple reasons for the parole, not only one reason. So we leave it to the discussion of the administration. They have definitely pondered over it and they are not fools to unnecessarily grant parole without any reason and then land into some soup. So definitely there must be some reason. But I'll tell you one thing. I beg to differ with the views taken by our learned friend Mr. Som about the judgment first he cited. See, the first judgment what he cited was on an altogether different point. About that life sentence is a full life sentence and it cannot be remitted, means it cannot be commuted. That is what the law is. So it is not got nothing to do with parole. But parole is something what a view is taken is for the humanitarian grounds that a person is a human being inside a prison. He may be a hardened criminal, but there is a reformative theory. Let him go out, mix with the society, and come back again.
How many times, sir?
Okay.
How many times?
Okay.
200 times since 2020? 15 times since 2017?
I am also coming to this thing. But is it, Griha ji, the case that when he has been released for the 15th time, therefore the people are shouting against him? That is not the case. When Rahim was released for the first time also, there was similar outcry. So the outcry is also political one. I am not saying about Anshul ji. He's got definitely
Sir, I wish it was a political one, because none of the political voices other than Pratik Som have chosen to join us. No political party from Haryana chooses to go ahead and counter this repeated parole or furlough that Gurmeet Ram Rahim is granted every now and then. Because it suits the purpose, and that is what the argument is, and that is what we are questioning.
No, these laws are meant for everybody, not only Ram Rahim. There are more hardened criminals than Ram Rahim. Even they are given. Let us take the case of today's only. This thing, Umar Khalid. Even he was released twice earlier. So that time nobody.
Even he was not granted bail by the Supreme Court, sir. And good, you made that analogy. But Gurmeet Ram Rahim, who is a convicted rapist, he has raped 2 of his disciples. बेटी बचाओ की बात करती है हरियाणा सरकार. Where is the Haryana government right now to oppose that repeated furlough and repeated paroles that have been granted to Ram Rahim?
Griha ji, charges against this Umar Khalid are far more serious. He's done a great harm to
And
the
you're saying
nation.
rape and murder are not serious charges, sir?
No, they are also serious. I don't say that he's not serious.
All right.
He's a criminal. He
All
should
right.
be punished.
We don't want it to be a one-to-one. Pratik Som, what do you make of this defense that's coming in, the one-off that's coming in for Gurmeet Ram Rahim, and yet the government in Haryana is staying mutely, they are mute spectators, they're silent about these repeated furloughs, they just shrug their shoulders, they say, we don't know, how is it happening?
See, there has to be parity when insofar as parole or remission is concerned in the executive decisions. I think this repeated parole is also violative of Article 14 and 21 of the Constitution. Why I say so? Article 14, it also there needs to be a parity and equality among all the prisoners. Why they are not given 400, 500 days of parole in let's say 3,000 days of imprisonment? There is not as far as data is concerned, I don't think there is more than 2-3% of parole applications which are allowed. In this case, it is more than 10%. On Article 21, why it is violative? It is also hampering and attacking on the dignity and also honor of the victims. So it has to be seen by the executive decision. See, we have to.
But why is it not contested? Is my question.
About the things which
why
gives
is it
the
never contested?
Mileage. But we also have to be mindful of our constitution that the state executive decisions do not violate the articles of our. We are basically enshrined in our constitution.
Kisle, would you like to take that? Kisle Pandey, why is it never contested?
No, please imagine, who do you expect to contest? The girls who are already tortured at the maximum?
At least they
or
are.
The system who is
they are
granting
the only ones who are.
Parole. I'm
the
sorry?
Betis of Haryana are. They are the only ones who are.
Yes.
The Sarkar
And
is
one
not.
more thing I must add here. The judgment which Mr. Som has cited are very relevant to the present subject matter, and Mr. Som is a celebrated lawyer as well. He knows what he has read, and I am very much in consonance with that. And having said so, what message you are giving to the girls of our country? What message you are giving to the criminals that you keep on raping our daughters and you will get the benefit of furlough or parole or a bail? Is it the message we are ready to give? Is it the country of our dream? And I have already beseeched, I have already prayed, I have already begged Honorable High Court, I am again beseeching that this is a high time that the cognizance of this conduct must be taken by Honorable High Court. Having said so, the overall process, suppose if we talk about this is there was some need or some urgency, you have rightly addressed it 15th times. You kindly check and you will find a absolute flaw as to prior to the application of this convict Ram Rahim, how many applications were allowed, and you will find definitely that
would you see a duplicity in judgment when it is about this case of Gurmeet Ram Rahim as opposed to another rape convict Kuldeep Singh Sengar? He was in the news very recently.
Well, it was thanks to you and thanks to your team, you have raised the voice so vigilantly that the CBI was compelled to file the SLP immediately without wasting any time. Otherwise, it would have been months and months. So thanks to your channel and thanks to your vigilance, your intelligence, that you took up the matter without any delay.
अंशुल, राम रहीम के केस में कौन आवाज उठाएगा? आपको क्या ये एक हारती हुई लड़ाई दिख रही है, अंशुल?
बिल्कुल नहीं, हम लोग 2002 से लगातार इस लड़ाई में हैं और मैं यहाँ ये भी बताना चाहूंगा कि मेरे फादर के जो मर्डर केस में अपील जो ट्रायल कोर्ट के फैसले को चैलेंज किया गया राम रहीम द्वारा, वो अपील लगातार सुनी गई माननीय पंजाब एंड हरियाणा हाई कोर्ट में और उसकी जो आर्गुमेंट्स हैं वो कंक्लूड हो चुकी हैं और फैसला जो है पंजाब एंड हरियाणा हाई कोर्ट ने रिजर्व रखा हुआ है। तो लगातार हम लोग अपनी जो लीगल बैटल है उसको लड़ रहे हैं और उसके अलावा भी मैं ये कहूंगा कि मेरे फादर एक मीडिया पर्सन थे, उनकी गुरमीत राम रहीम या डेरा सच्चा सौदा के साथ कोई ज्यादती दुश्मनी नहीं थी, तो उन्होंने अपना जो पत्रकारिता धर्म था वो निभाया। उन्होंने अपने अखबार के मार्फत जो डेरा सच्चा सौदा में जो भी इरेगुलरिटीज हो रही थी उसको एक्सपोज किया और डेरा हेड को एक्सपोज किया। इसी का खामियाजा उन्हें भुगतना पड़ा और उनकी हत्या कर दी गई। तो मैं लगातार ये बात कहता रहा हूं कि एक मीडिया पर्सन का कत्ल हुआ और उनके कत्ल की लड़ाई को सबसे पहले अगर जिम्मेवारी बनती है तो वो मीडिया की बनती है और इस मामले में भी मीडिया को इनिशिएटिव लेना चाहिए और बड़े लेवल पर जो वॉइस है उसको रेज करना चाहिए ताकि राम रहीम जैसा जो हीनियस क्राइम्स में जिसको सजा हो रखी है और कई सारे मामले जो हैं वो अभी अंडर ट्रायल हैं जिसके गवाहों को कंप्लेनेंट को थ्रेट भी है, तो ऐसे मामलों में ऐसे अपराधी को बार बार पैरोल दिया जाना कहीं भी न्यायोचित नहीं है। तो मेरा ये मानना है कि सबसे पहले मीडिया को वॉइस और
thank you so much for presenting all of those facts before us. And gentlemen, thank you so much for joining us. The apparent contradiction between granting temporary freedom to a convict of serious gender crimes and broader government campaigns against violence towards women. Lots of gaps here. Stand by Beti Bachao is all we say. Thank you so much for watching.
In a city that never sleeps, every decision matters. From roads to rains, from safety to services, every rupee counts. One alliance versus fractured opposition. Who will Mumbai choose? Ballot Maximum City. Complete coverage on CNN News 18. This is News 18 Network. India's largest news network.
Is with us. Also with us is Shahid Ali, another lawyer who joins us today. Let me actually begin with, in fact, Harsh Dayash. I want to understand from you, what do you make of the observations, particularly with the court stressing that in such cases, we're talking about the delay in trial, that cannot be used as a trump card. And this was a significant observation that has come out of the court today.
Griha ji, when we talk about the today's court judgment and also the media trial that is being done, the media pressure that is being built by the left lobby, the Congress lobby and the Islamist lobby in the country to grant these people bail, and them repeatedly calling Sharjeel, Imam and Umar Khalid as intellectuals, I would like to point out one plain and simple fact, that the jihadi intellectual provides the shoulder on which the jihadi extremist places his guns and targets Hindus. This has happened in Bangladesh, this has happened in Pakistan, this has happened in Kashmir, and this is happening all across India at the moment. These people are not only conspirators, but they are also rioters and terrorists. Let's not forget that. And why am I saying this? Because Sharjeel Imam, it cannot be denied, there is a clear video where he calls for the chicken neck of the country to be cut and the passage between the other parts of India and Northeast to be cut down. He is clearly asking the Muslims in that particular video that the Muslims should come out and that chicken neck belongs to Muslims, and if they gather in number of 5 lakh, then they will be able to sever the chicken neck from the rest of the country. Now coming to the court's, judgment which says that the delay in trial does not translate into automatic bail. It is plain and simple that the delay in trial is a strategy of the defense, because the defense knows there is concrete evidence against these culprits who were involved in Delhi riots, who